Hello everyone and welcome. It is 3 p.m. Eastern and we are going to go ahead and get started. My name is Jessica Enix and I'm with the ASA staff. I would like to welcome you to today's ASA webinar. This is ASA's second pop-up webinar relating to the COVID-19 pandemic, and I just wanted to let you all know to please continue watching your ASA emails and the ASA website for future webinars. As current information becomes available, we will do our best to get that information out to you. Also, please note that the slides and the webinar will be on the website at 5 p.m. Eastern this evening, so you can access that information there. Before we begin, I would like to review a few points of protocol so that you'll get the most out of your webinar experience. Remember, you are listening to the webinar via a conference service. If you are disconnected, repeat the steps that were given to you by the ON24 registration email. In order to reduce background noise, please be aware that all participant lines are muted throughout the webinar. If you have any questions during the presentation, please type them in the Q&A box. A Q&A icon is located at the bottom of your screen. All questions will be addressed at the conclusion of the webinar. Please note that today's program is being recorded and again will be available to view on ASA's website. Presenting today will be Misty Gutierrez. Misty is a board-certified construction law by the Texas Board of Legal Specialization and is a partner at the law firm of Thomas, Feldman, and Wilshusen. Misty advises clients from all segments of the construction industry regarding employment and construction matters and has experience in handling and resolving disputes through mediation, arbitration, litigation, and the appellate process. Ladies and gentlemen, please welcome Misty Gutierrez.
Good afternoon, everybody. Thank you for taking the time to attend the webinar today. I appreciate everyone being here. It's difficult times for everybody, so I'm glad you were able to make the time to do this. This webinar really is intended to address two specific topics, and that is the mandatory paid sick leave legislation that was passed by the federal government and the limited expansion of FMLA. So that's primarily what we will be talking about today. Both of those pieces of law went into effect on April 1st, so that was yesterday, and they're scheduled to continue as long as they're needed or until December 31st of 2020. So the first question is, who has to comply with the mandatory paid sick leave? And that is going to be employers with fewer than 500 employees. So if you are a larger employer that has more than 500 employees, this legislation does not apply to you. And the number of employee calculation begins on the date that the requested leave starts. If you have already laid off employees or furloughed employees, they won't count toward the total. Also, since it's based on the date that the leave starts, the leave start date can be different for different individuals. So there could be instances where you have to comply for some individuals and not others because it's a fluid date on when they're calculating the number of employees. So the next question is, when is paid sick leave required? And I've broken this down into two categories because there are really two categories of the amount that you have to pay your employees. So we'll get into that detail in a little bit, but know that the reason for the breakdown is because that's what's going to determine how much sick leave you have to pay, the dollar amount. So under the primary category, we have when the employee himself or herself is under a federal, state, or local quarantine or isolation order. We also have when the employee is told to self-quarantine or when the employee is experiencing symptoms of COVID-19. So the primary category really revolves around things that are directly impacting that employee. The secondary category is when the employee is caring for someone else under a quarantine or isolation order, when they're caring for a child whose school or daycare is closed, or when the employee is experiencing a substantially similar condition to COVID-19. So at least the top two in that second category are when the employee is helping someone else out or caring for someone else and the employee is not necessarily directly affected or having symptoms. So to break that down into a little bit more detail, under the first and second points, which fall into that primary category, when the employee is under a quarantine order or has been told to self-quarantine, you may be required to provide paid sick leave, but you also have to have work available for the employee, or there have to be extenuating circumstances that prevent teleworking. So if you're able to allow your employees to telework, then even if there is a quarantine or isolation order, that employee is not necessarily entitled to paid sick leave because they're able to do teleworking. This extenuating circumstances that prevent teleworking means something like having a power outage. So you've told the employee that they're welcome to work from home and they're trying to work from home, but something like a power outage actually prevents that. This was a specific example that was given in some new rules published by the Department of Labor on how to interpret these statutes. And interestingly, that happened to me earlier in the week. I was working remotely trying to get things knocked out, and we lost power for about 3 hours, which kind of stopped me dead in my tracks. So in that instance, you know, if I were an employee, I could have applied for paid sick leave. An example that I have at the bottom of the screen also came directly from the guidance that has recently been published by the Department of Labor. So this really kind of reins in how an employee can get paid sick leave under those first two requirements. So the example they give is if a cashier at a coffee shop is unable to work because the coffee shop closed down because they can't get enough business, or because a local quarantine order required that coffee shop to shut down, the cashier is not entitled to paid sick leave because there's not work available for that cashier to perform. So the cashier can't do their job via telework, the business is completely closed. In that instance, you do not have to pay paid sick leave. If your business is closed, either because of economic reasons or because it is subject to an isolation order, if you are in an area where construction is not deemed essential and you have to stop all of your construction work, then you may not be required to pay sick leave to your employees who are unable to do telework for their jobs. If you're in an area where construction is deemed essential and you're able to continue providing work to your employees, then in that circumstance, they have to self-quarantine. You may have to provide this paid sick leave. So the third point under our primary category is if the employee is experiencing symptoms of COVID-19. And the specific symptoms are listed on the CDC website. So those are fever, dry cough, shortness of breath. Those are the primary symptoms. And then the next symptoms are when the CDC recommends getting emergency treatment, but that's trouble breathing, persistent pain, pressure in the chest, a new onset of confusion or inability to arouse, and then bluish lips or face. So if the employee is experiencing those symptoms, they may be entitled to get paid sick leave, but the paid sick leave is limited to the time the employee is seeking a diagnosis. So if they call in and say, I can't come into work today, I have a fever, I have a dry cough, I'm going to try to make a doctor's appointment, from the time they get their symptoms until they're trying to get the doctor's appointment, they can get paid sick leave. And until they see a doctor and the doctor says, yes, you can go to work, or no, you have to self-quarantine or take additional action, they could get paid sick leave. However, if this is an employee who's able to telework, who can work from home and their symptoms aren't so severe that it would prevent them from being able to work, then from the time they, call the doctor and make the appointment until they get the appointment, say the next day, they wouldn't be entitled to paid sick leave because they can still perform their telework jobs. So there's a lot of gray area as to exactly when you do and don't pay the sick leave. But if the employee is actually able to work, they typically aren't entitled to paid sick leave. So if work's available and they're not actually going to an appointment or don't have severe symptoms, they may not be entitled to the paid sick leave. So on the fourth point, which is in our second category where they get the lower paid sick leave, if an employee is caring for someone who is under a quarantine or isolation order, they may be entitled to paid sick leave. Again, if the employer has work for the employee or there are extenuating circumstances that prevent teleworking. So just like before, if your employee is able to telework from home and they're caring for someone else and the caring for that person only takes half of their day and they can work the other half of their day, then they may only be entitled to a half day's worth of sick leave. They also have to have a personal relationship with the person that they are caring for. So that's a pretty broad definition of who they can be caring for. It can be a spouse, it can be a roommate, someone that they're close to. That's the wording in the guidance that we were given, a personal relationship. So I had a question this morning about whether an employee could use this because a girlfriend that they live with is ill and needs help. And that this would probably apply in that circumstance. But again, if you're able to telework, you may not be entitled to it. If you have a job that you can't telework from, then you would be entitled to paid sick leave. That person also has to be under a local order or has to have been told to self-quarantine after seeking a medical diagnosis. So they can't just decide on their own that they want to self-quarantine. They actually have to get a medical diagnosis to be able to do that. And then the fifth point is when the employee is caring for a child whose school or daycare is closed, again, and the employee can't perform their work remotely while actually caring for the child. So, if you have the ability to maybe work early in the morning before the child gets up or during the child's nap time or late in the evening, you may not be entitled to that paid sick leave. You're only entitled to it during the times that you actually can't do your work. You also have to be able to state that there is no other individual suitable to care for that child and that the child's regular caregiver isn't available. So if I want to try to take paid sick leave, but my husband is the primary caregiver for my children, I don't automatically get paid sick leave just because they are out of school. He's the primary caregiver, and that's the way it's always been. That doesn't entitle me to get to stay home and recover paid sick leave as well. And then the fifth point under the second category is when the employee is experiencing a substantially similar condition to COVID-19. I do not know what this means. I have looked high and low for a definition and have found no guidance whatsoever. The note in the original act says it's to be defined by the Secretary of Health and Human Services. As far as I can tell, they have not done that yet. Even in the rules that were published, they didn't address this. So it's kind of a mystery hanging out there what that means or when you have to provide paid sick leave in that circumstance. So we talked about our primary and our secondary categories, and this is where it comes into play. If the reason for the paid sick leave falls under those first 3 points that we designated as the primary category, the employee is entitled to recover their regular rate of pay that's capped at $511 per day and a total of $5,110 per employee. So it's intended for up to 80 hours of work. So if your employee would typically earn more than $511 a day, the most that they can get is $511. If they earn less than that, then they would get whatever their typical daily rate would be. If it is a part-time employee, then you take a 6-month average, if their hours vary, of what they would earn over 2 weeks. If they have regular hours, then you just use that. And of course, their pay can't be less than the minimum wage. Again, those primary categories were typically when the employee himself or herself is experiencing symptoms. The secondary category tends to be when the employee is caring for someone else unless they fall into that sixth mystery, substantially similar condition category that we don't really understand. So if they're in the second category, the employee can receive 2/3 of the employee's regular rate of pay, but it's capped at $200 per day and $2,000 per employee for the paid sick leave. So again, if the employee, 2/3 of their pay would be more than $200, they still don't get more than $200. That's the cap, and that's for up to 80 hours. One question I've asked is, can the employee use this paid sick leave more than once? So if they themselves become ill and need to use it, and then later on and then a family member becomes ill and they need to be out a second time, the answer is no. You only get up to 80 hours total. This is what we just covered, the average of 2 weeks for part-time based on 6 months data. Now, one thing to note is that this federally mandated sick leave is in addition to any other leave that you already provide, part of your company policy, or that's required by local law. So if you are already giving them 2 weeks of PTO, or if you're in a jurisdiction that requires you to provide paid sick leave, that will be in addition to what you are required to provide under these laws. You also cannot require an employee to use other sick leave before they use the federally required sick leave. So if you give them PTO and they want to hang on to that, they can use this and then still hang on to the company-provided PTO. Who gets the sick leave? It is all current employees. It doesn't matter if they're full-time or part-time, and there's no waiting period. So if they started working for you yesterday and need to take sick leave starting tomorrow, they'll be entitled to receive that. That was the overview of the mandatory paid sick leave. Now we're turning to the emergency FMLA expansion. And this, again, applies to employers with fewer than 500 employees. So the regular FMLA statute applies to employers with greater than 50 employees. So many employers who have not typically had to comply with the FMLA at all have to comply with this emergency FMLA expansion. And just like with the paid sick leave, the number of employees they have is based on the date that the leave for that employee starts. And again, furloughed and laid off employees won't count toward your total. So the good news here is that the scope of the FMLA expansion is very limited. It is not nearly as broad as the mandatory paid sick leave. The emergency FMLA expansion only applies if an employee is unable to work in order to care for a child under 18 years of age because the child's school or daycare is closed due to a public health emergency. And generally, a child is someone that you have legal responsibility for. So your own son or daughter, your stepchildren, if you have a legal ward, those kinds of relationships are when this emergency FMLA applies. It's also a little bit more restrictive on when you have to start providing it. So whereas under paid sick leave, it begins immediately, FMLA leave doesn't begin until that employee has worked for you for at least 30 days. There's also a rehire provision in there. So if you're bringing someone back that's previously worked for you, as long as they worked at least 30 of the 60 days before they were laid off before, then they'll be entitled to immediately take advantage of the emergency FMLA leave. So how much FMLA leave are they entitled to? Well, you don't get FMLA leave for the first 10 days, but you could use the mandatory paid sick leave to cover those first 10 days or other PTO that's provided to the employee either through the company or mandated by another local law. After the first 10 days, then the employee is entitled to get 2/3 of their regular rate of pay up to $200 a day. So it's just like those Category 2 paid sick leave. However, they can get the emergency FMLA for up to 12 weeks, and there's a $10,000 cap on that. So a much bigger cap and longer period of time that they can recover this emergency FMLA. Again, this only applies to this limited scope. Other FMLA regulations will apply, such as notice requirements and certifying the need for FMLA. Also, if you are an employer who FMLA has applied to in the past and you have employees who have already used some of their FMLA leave, the total that they can use isn't expanded, so it's still 12 weeks. So if they were out for 2 weeks earlier in the year and have used 2 of the total of 12, and then they would only get 10 from this point. So the FMLA leave, the regular rules still apply if you have previously been providing FMLA leave to your employees. Okay, so what happens when the emergency FMLA leave ends? You're required to restore the employee to the position that he or she held before, as long as no action unrelated to the employee's request for leave has, or related to the employee's request for leave has eliminated the position. So if due to the economic downturn, you have had to eliminate a number of employees or have had layoffs, then of course you wouldn't necessarily have to return that employee to their position. However, if you want to terminate them because they have been on FMLA, then that would be a violation and you can't do that. There's also an exception for employees with fewer than 25 employees, which says that they don't have to restore to the prior position if the position doesn't exist due to changed operating conditions that are resulting from the public health crisis. However, there's some strings there. The employer has to make reasonable efforts to restore the employee to an equivalent position and has to try to continue to contact that employee for up to a year. So that's really kind of a heavy burden on an employer to have to try to keep contacting this employee for a year to refill that position. Okay. However, there are additional exemptions available under both the paid sick leave or the and the FMLA provision. So if you have fewer than 50 employees and you have an officer of the business determine the following, then you can try to get exempt from the paid sick leave or the FMLA. So that would be if leave payments would result in financial obligations exceeding revenues and causing the business to cease operating. If providing sick leave or FMLA leave basically runs you out of business, then you can try to get an exemption. The other 2 points are if the absence of one or more employees requesting leave would entail substantial risk to the financial health or operating capabilities because of those employees' specialized skill, knowledge of the business, or responsibilities, you can try to get an exemption. Or if there would be an insufficient number of workers able, willing, and qualified to work when needed for the business to operate, you can try to get an exemption. The question I've received a lot is, how do you apply for an exemption? And we don't know. There has not been additional guidance published yet. The Department of Labor is supposed to give us some additional guidance later this month. For now, all they've said is that you have to document the facts and circumstances justifying the denial of leave, and you have to maintain the records in your own file. So it doesn't give a whole lot more detail than that, but make sure you're documenting why that would cause your business harm if you don't want to provide the paid sick leave and think you would qualify for an exemption. Now, the statutes apply for the use of intermittent leave in certain circumstances, which means you don't necessarily have to take the paid sick leave or the FMLA leave all in one big block. This is permitted only if you're teleworking. If the employee's working remotely and maybe they need to take 2 days a week in order to care for their children, that would be allowed. You cannot use it, though, if you're working on the job site and showing symptoms, because, of course, in that case, they want the employees to be away from others and quarantined and not intermittently using that sick leave. So it can be used intermittently, but only for your workers who are allowed to telework. So here is the documentation that you can require of your employees in order to take this leave, and this applies to both the paid sick leave or the expanded FMLA. The employee has to provide a statement including his name, the date the leave's requested, the qualifying reason for the leave. That means one of those 6 points in our primary and secondary categories. And the employee needs to provide a statement that the employee is unable to work or telework because of that qualifying reason. In addition, they need to provide the name of the healthcare provider who told them or the person they are caring for to self-quarantine, or the name of the government entity that issued the quarantine, or if they're trying to care for a child because the school or daycare is closed, they need to provide a statement that includes the name of the child, the name of the school or daycare provider, and a statement that there is no other suitable person available to care for that child. Now, interestingly, what they didn't require for either of these is a doctor's note. They only ask for the name of the doctor doing that, but the employee is the one that has to provide that statement. You would also need to keep these records if you're intending to apply for any of the tax credits that are available to you, which we'll get to in just a minute, but this is the same documentation that the IRS is requiring if they need backup for the tax credit. You must continue to provide the same health care benefits that you were providing to your employees before while they're taking paid sick leave or the expanded FMLA, and employees are expected to pay the same premiums that they were paying before. You need to keep records for 4 years. And a couple of additional requirements that are in the Act. You can't require an employee to find shift coverage in order to use their leave. There is also a required notice that you have to post informing employees of their rights under these acts. It's available on the Department of Labor website in both English and Spanish. And recognizing that many people are no longer working at a specific location, it can be sent by email, it can be sent by mail, it can be posted on either your internal or external web servers or websites so that your employees can see these notices. If you still have employees out in the field, if you've got a job shack or something like that, it should be posted there. Otherwise, they should be informed during their toolbox talks. Here is in very tiny words just what it looks like. Again, it's available on the Department of Labor website. Finally, there is a non-retaliation provision included that applies to both the paid sick leave and the expanded FMLA. You can't terminate discipline or discriminate against an employee who's trying to use this leave. The consequences of doing so are an FLSA violation, which means fines, having to repay the lost wages, potentially liquidated damages. In some cases, criminal penalties could be possible. Okay, so a lot of that there are payroll tax credits. So you can receive up to a 100% tax credit for qualified sick leave and FMLA leave. This is on the employer's taxes only, not the employee's taxes. And you can also get credit for the employer's portion of qualified health plan expenses. Note that you don't get credit for providing any other leave. So if you're providing your employees a leave under your own policies or under other local laws, those aren't going to qualify you for the payroll taxes. That's about as in-depth as I get on these. I am not a tax professional. If you have questions about these, I strongly encourage you to talk to your accountants or your financial advisors who can give you more details on the payroll tax credits. Another thing that's been talked about a lot with these bills is the Paycheck Protection Program that allows small businesses of less than 500 to qualify for federally backed loans that they can use to help cover payroll, paid sick leave, insurance premiums, rent, utility, and mortgage payments. It is limited to those kinds of things, so you can't use it broadly for whatever you want. If you retain your full staff and payroll, then you could have all of your eligible expenses for up to 8 weeks forgiven completely. And these need to be processed by June 30th. I think the applications go up tomorrow, April 3rd, and my understanding is that these will be widely sought after, so sooner is better if you are thinking about taking advantage of one of these. Again, I have limited detailed knowledge beyond what I'm providing here. Talk to your finance folks, your accounting folks, and see if they can give you more information. Also, your bank should be able to give you some information about applying for these loans. Also buried in the CARES Act was a provision for federal contractors, for federal agencies who are receiving money under the CARES Act. They may be able to reimburse paid leave that's provided to contractors in order to keep their employees and subcontractors in a ready state if the project they're working on is subject to a shutdown. Haven't seen a lot more guidance or information other than what's in a statute, but if you're working on a federal project that's been shut down, it would certainly be worth looking into whether you might qualify for this. Okay, leave this up for a minute. Here is a list of resources. The best resource that I have found. They have fact sheets on their websites. They have Q&As. They have the posters that you have to put up there. There's a long link included here, but if you go to the DOL website, they will. You should be able to find it. All of these major governmental entities have great big coronavirus banners at the top of their screens. The CDC has some good guidance as well, and then the small business loan information is available at sbc.gov. So you can take a look at those and see if there's anything that's helpful for you on those websites. They can give you a lot more detail than we were able to get into today. And that was the end of what I have. If anyone has any questions, I will turn it over to Jessica and we can address questions.
Okay, great. Thank you so much, Misty, for your presentation. And we do have quite a few questions. I will start with the first one. We are under 15 employees. Do we have to comply with the FMLA requirements or are we exempt?
You are not exempt. There's not a minimum number of employees for the expanded FMLA, so you do have to comply with that. But you only have to comply with the expansion. So the rest of the FMLA statute doesn't apply to you, only the expansion, which is limited to caring for a child because their school or daycare is closed.
Okay. Does the paid sick leave apply to union trades under contract, which does not provide paid sick time?
There is some language in there about joint employers and trades. I did not look into labor unions specifically. I believe that it does, but I would talk to your union reps.
Okay. To use the Paycheck Protection Program loan, are only sick employees pay eligible to use the loan, or can we use the loan to retain and pay all our employees?
You can use the loan to retain and pay all of your employees. That's what they want to do, is keep businesses keeping their employees working and getting paid.
Okay. We are a subcontractor and we hire subs who are not considered employees. So how do we get money for them?
These only apply to employees, so they do not apply to 1099s or subs. Did you say you're a federal contractor? Talking about that, can you reread the question, Jessica?
Hang on just a second.
Did you lose it?
I have lost it. Hang on just a second. I will go back and find it.
Okay. If you're asking about the federal statute that I touched on, it does specifically say subcontractors and employees, but I've not found additional guidance other than it may be out there. So I would talk to the parties that you're contracting with and find out if you qualify on that.
Okay. What if the company does not offer FMLA?
If you have fewer than 500 employees, you are required to offer the expanded FMLA.
Okay. If someone gets a doctor's note that does not reference COVID-19 and the doctor says the employee needs to stay home for 5 work days, again, it does not mention COVID-19. I assume this isn't covered under the new mandate. I believe this employee is just stressed out.
What the Act specifically says is if the employee is told to self-quarantine. So I think you need to look at whether that doctor's note says that they can't go anywhere, that they're required to quarantine versus you just need to stay home. I think that there's a fine line right there between being told to stay home and being told to self-quarantine. So they have to be told to self-quarantine in order for this to apply.
Okay. Is a state shelter-in-place order equivalent to a quarantine or isolation order?
Yes. So, yes, the Act specifically says under federal, state, or local quarantine orders. So that could be due to your federal, it could be due to the state. I'm in Texas where we have not had a broad statewide quarantine order, but we have seen those orders in place at both the county and the city. Any of those were here.
Okay. What if we have a positive test on a job site and we tell the rest of the crew to go home and self-quarantine for 2 weeks? Do we have to pay?
Yes. If you're telling your employees to go home and self-quarantine and there's not work available for them, if there's not work available for them because of the quarantine, it sounds like you would fall under that exception based on the example that they gave in the local, because they can't go to any job site. So I don't know that you would have to provide sick leave in that circumstance.
Okay. We have multiple entities with separate tax ID numbers and no single entity has in excess of 500 employees, but as an entity-wide, we are over 500 employees. Do we aggregate all entities to determine the total head count? All entities office in the same building, share accounting, and have common ownership.
There's guidance in the statute on that, and I can't tell you what the answer is off the top of my head. I would have to look back at the statute, but there is guidance on how that would apply.
Okay. Is this federal or for each state?
This is federal law.
Okay. My wife is off due to being hospitalized for pregnancy complication. Doctor states he can't. Oh, I'm sorry, my employee is off due to wife being hospitalized for pregnancy complication. Doctor states he can't leave and come back due to possible exposure to COVID. He doesn't want to leave her alone. He wants to know if he can get paid the 80 hours. Is he eligible for it?
I think because it sounds like the doctor has told him to self-quarantine. So yes, I think he would be eligible under the primary category and certainly under the secondary where he's helping to care for his wife.
Okay. This person is asking if there is relief for FMLA for employers with less than 50 employees, and was that to be defined after April 2nd?
There is, that is where you can apply for an exemption, where you needed to document the reasons for the exemption, which is basically if complying with this would put you out of business or not allow you to maintain critical staff, but they haven't given us additional guidance on exactly what you need to do to apply for an exemption.
Okay. When you state the paid sick leave, the 2 weeks applies to all current employees. Does this include multi-employer union employees?
It does apply to joint employer agreements, and I am not sure on union employees.
What if the other spouse is already at home and able to care for a child?
In that case, one of the requirements to get the leave to care for a child, the employee has to make a statement that there's no other suitable person available to care for the child. So if they've got someone who's already receiving leave or who was otherwise available to care for the child, they're not entitled to receive leave for that.
Okay. We have high school age interns. Are they eligible for sick leave?
If they are part-time employees, if they're receiving pay, yes. There's no age limit, and it doesn't matter if they're part-time or full-time or however many hours they work, yes.
Okay. Can you clarify regular rate of pay? Hourly employees make specific amount per hour. Is it hourly rate times 8 hours, or is it average they made per day, including overtime?
It's average per day, including overtime.
Okay. Can the employee get the 10 days for themselves plus 10 days to care for someone else?
No. You only get the 80 hours once.
Okay. Can we ask for proof that there are no other child care options available?
What the statute and the guidance says is that the employee has to give a statement that no one else is available. There's no requirement beyond that. So I don't know that you can. I don't know what the consequences would be if you did.
Okay. Just to be clear, if a job site is shut down, we don't have to pay sick leave for those employees affected. Is that correct?
Right.
Are we required to pay benefits for union employees under this act if they qualify?
In general, you have to continue to pay health care benefits. Other benefits, I don't know, and I don't know union specific. And I apologize, I did not focus on union rules.
Can an employer ask an employee to self-quarantine if they have reason to believe they may have been exposed to COVID-19, but the employee is not symptomatic?
That I don't know. I haven't seen that addressed in this act. I think certainly if you are going to continue to pay the employee or have them telework, you could do that. To do it without pay, I don't know, because that's not something that's answered in the information that we have right now. Now, keep in mind that it could be an OSHA issue as well. OSHA has not specifically there's not a specific OSHA regulation on the book that says COVID-19 that specifically addresses COVID-19, but they do have OSHA statutes that address the spread of disease, and the interpretation right now is that COVID-19 would fall within that. So you could be looking at an OSHA violation if you have employees working or aren't observing hygienic practices.
Okay. Can owners of corporations apply for unemployment benefits?
There are some rules in the Act that apply to self-employed persons and sole proprietorships, so the answer is maybe. And I don't have a fuller answer than that, but you may be able to.
Is there a new FMLA form for the employee to submit or leave the standard FMLA forms?
I think it's just the standard FMLA form. I haven't seen a new form out there yet.
What if an employee brings a letter from his doctor stating that he has a history of severe asthma, pneumonia, and heart disease, stating that he has a very high risk of complications if he contracts COVID-19 and wants to be furloughed to stay safe?
Well, I think if they want to be furloughed, if the employee is requesting to be furloughed, you might want to let them do that. I think that would also fall under the paid sick leave requirement where the employee is told to self-quarantine. It didn't sound like they used that exact language, but it sounded pretty close to a self-quarantine.
We are in California where they issued a statewide quarantine. Currently, employees are using unemployment as we are listed as non-essential. How does this paid sick leave FMLA apply in this circumstance? Misty? Hello, Misty, are you still with us? We'll give her just a second to possibly jump back on. She may have been disconnected. Misty, are you there?
Hi, Jessica. Just got back. The call dropped.
Okay. I will read that question, or did you get that question?
No, the last thing I got was something in California, and then you started breaking up and disappeared.
Okay. This question is, we are in California where they issued a statewide quarantine. Currently, employees are using unemployment as we are listed as non-essential. How does this paid sick leave FMLA apply in this circumstance?
My understanding is that you get either or. You either get paid sick leave or you get unemployment. You don't get both at the same time.
Okay. If an employee said they were indirectly exposed and have quarantined, can the employee or employees who work close to him be quarantined and paid the 80 hours?
You need that self-quarantine order, or you as the employer need to make the decision to have them self-quarantine. Again, keeping in mind that if you're not quarantining them, you may be in violation of local order. You could also be facing an OSHA violation.
Okay. Our corporate lawyer said that a stay-at-home order is not the same as a quarantine isolation order. Can you please clarify?
Well, I do not want to go head-to-head on him. It sounds like he may be interpreting this differently than I'm interpreting it. I'm interpreting the act that says if your city or state or county is telling you to stay home, that will trigger the first category. But certainly for specific advice for your specific jurisdictions, speak to your local attorneys because, you know, I can't give advice on all jurisdictions.
Okay. Let's see. Just to clarify, everyone, we will have the slides available on the website. I know a lot of people are asking that question, so I do just want to clarify that the slides and the webinar will be available. We've got, Misty, do you have time for a few more questions?
Yes.
Okay. We contacted the DOL in Pittsburgh. He said because we are not under 50, none of this applies. We are getting mixed guidance. We laid off everyone over 10 days ago. The county is now on a stay-at-home order since no work is available. Does any of this apply?
I think it does because it applies to employers under 50, but if there's no work available, then you don't have to pay the paid sick leave. And if you've laid off your employees already, then they can get unemployment, so they're not entitled to the paid sick leave.
Okay. The employer payroll tax credits we can take advantage of include Social Security and Medicare. Is that correct?
I do not know. I think that's correct, but talk to your tax people. I am not a tax attorney, so my knowledge base is very limited on the tax issues. Anything regarding the taxes, the payroll tax credits, definitely talk to your financial advisors, your accountants, your tax people to give you better information on this. This is really intended to give you a tip-off to look further into these.
Okay. Hang on, I'm going to get a couple more questions here. This person asks, we split our guys into two groups. One group works 1 week while the other group stays at home to quarantine, then switch the next week. When they stay home, we are going to pay them full sick time, making sure this sick pay doesn't have to be continuous as long as it doesn't go over the 80 hours.
Okay, that's a good question. It sounds like you're voluntarily giving them the sick leave. I would talk to your financial advisors about how you're doing this, because if you're providing sick leave under circumstances that don't fall within the categories we've talked about today, you may not be entitled to the tax credits. And so what you're doing sounds more voluntary than what's required under these federal ordinances. So I would suggest talking to your tax professional to make sure you'll get the credits the way that you're handling this.
Okay. This person asks, what if an employee has to take off because his place of residence kicks him out because of the COVID virus? We have to pay for him a place to live until the pandemic is over. Would he be covered on anything?
I don't think so. I've not seen anything that addresses that type of situation.
Okay. We are essential construction business for infrastructure with skilled people. What is the recommendation for trying to take exemption? It seems like so uncertain if we can qualify.
It's very uncertain. You're really kind of taking a risk if you try to take that exemption before we have additional guidance in place. It may be from an economic circumstance that you don't have a choice, and in that case, just document as best you can but it's very uncertain without additional guidance.
Okay. Is there language in the expansion of FMLA for handicapped children over 18 years old who attend daycare?
In the FMLA expansion, it covers children or a disabled child over the age of 18. So they would be entitled to either the sick leave or the FMLA if they have a disabled child over the age of 18 that they need to care for. I don't think the Act specifically addressed the children over 18 in the language of the statute, but the rules guidance did.
Okay. Can we apply for the expanded sick FMLA and also forgiveness of the SBA loan?
I think those are separate. So yes, I think you can do both.
When should we submit the employee the FMLA forms? Immediately when they say they are sick but haven't provided doctor paperwork, or after doctor paperwork?
I'm not sure on that. I'm sorry, I don't have an answer.
Okay, and do you have a reference of where folks can get guidance regarding the tax exemptions?
The tax exemptions, you might check the IRS website. They had a form up to fill out to get the payroll tax exemption.
Okay. Misty, I think we are going to go ahead and cut it off today. Again, if you have anything further you would like to address.
No, that's it. Again, thanks everybody for participating, and thanks, Jessica, for facilitating this.
Okay, again, thank you so much, Misty, for your presentation, and thank you all for joining us. Again, the slide deck and the presentation will be available on the ASA website at 5 p.m. Eastern Time this evening. So thank you all and have a great afternoon.